In most of this country, there's no limit on how much your landlord can raise your rent. None. Not a percentage, not a ceiling, nothing. More than 30 states have gone out of their way to keep it that way. They've passed actual laws saying no city inside their borders is even allowed to cap rent. So when the letter shows up, the one that says your rent's jumping from $1,600 a month to $1,950 starting in 2 weeks, and you get that drop in your stomach, and the first thing you think is, wait, are they even allowed to do that? And a lot of places, the honest answer is yes, they are. But that's only half of it. And the half almost nobody explains to you is the half that's actually on your side. How much they can raise it, that's one question. How much warning they owe you first, that's a completely different one. And that second answer was never up to your landlord at all. It's written into the law of your state right now, whether he bothers to follow it or not. Most people just pay the new number the week it lands. A lot of them didn't have to. Walk into any apartment the week that letter lands, and it's the same scene every time. That letter sitting on the kitchen counter, and somewhere near it, a drawer, a folder marked nothing in particular, the bottom of a bag by the door, a lease nobody's read since the day they signed it. Those two pieces of paper are about to decide more than the person living there knows. You've probably already had the bad night about it, the do the math at the kitchen table night. Most people only ever look at one of those two papers though, and it's the wrong one. So start with the question everybody asks first. How much can they raise it? And the answer isn't a number, it's a map. Whether there's any limit at all on your rent going up comes down to one thing. And it's not the thing you'd hope for, not your landlord's conscience, not how long you've paid on time. It's the state you happen to be renting in. That's the whole of it. Right now, there are 3 states in the entire country where a landlord raising your rent has to stay under a hard ceiling. California, Oregon, Washington. That's the list. California has a law folks call the Tenant Protection Act, and it says your rent can't climb more than 5% plus inflation in a single year, and no matter how high inflation runs, never past 10. Oregon did it first, back in 2019. Their cap this year lands at 9.5%. Well, 9.5% this year. It drifts a little every year with inflation. And Washington only just joined them, signed into law in the spring of 2025. Same shape as the other two, roughly 7% plus inflation, 10% ceiling. New York's its own creature. About 1 million apartments just inside New York City are what they call rent stabilized, and a city board sits down every single year and sets the number. This past year, 3% on a 1-year lease. But step outside those few places on the map, and a landlord can put whatever number he likes on that letter. And that's where most Americans actually live. More than 30 states haven't just skipped rent control, they've passed laws forbidding their own cities from ever trying it. Texas locked that in back in the 90s. Florida's had it on the books since 1977. So is your landlord allowed to turn your $1,600 apartment into a $1,950 apartment? In most of this country, on the number itself, yeah, he is. There's no percentage he broke, no line he stepped across. And even in the 3 states that do cap it, there's fine print. Brand new buildings, roughly the first 15 years, usually don't count at all, which is its own rabbit hole I'll leave sitting there for now. And that's the part that gets people, not the money even, the powerlessness of it. You did everything right. You paid on time, you kept the place clean, you were a good tenant for 2 years, and a piece of paper still shows up telling you the number went up $350 a month, and there's a date on it, and the date is soon, and nobody asked you anything. You're not part of the conversation. You're just told. I'll be straight with you. The first time that really sinks in, it feels like a mistake. Like there's gotta be some federal law in the background waiting to kick in. There isn't. Never has been. People keep waiting for the catch, the fine print that saves them, and in most states, on the number, there just isn't one. Washington, D.C. has floated the idea more than once, and it's quietly died more than once, but this is where that unread lease starts earning its spot on the counter, because there's one rule that covers almost everybody, in almost every state, cap or no cap, and it barely gets talked about. As long as you're inside a lease, an actual signed lease with a start date and an end date, your rent is frozen for that entire term. Your landlord can't stroll up in month 6 and change the number on you. Not in California, not in Texas, not anywhere, unless the lease itself handed him that permission somewhere in the fine print, which is the exact reason page 4 matters. That's usually where a thing like that would be hiding, if it's hiding at all. And the reason all of this bites so hard right now is the math sitting underneath it. In 2019, the middle rent in America, half of people paid more, half paid less, was $1,088 a month. By 2024, that same middle number had climbed to $1,498, 37% in 5 years. Paychecks underneath those rents barely twitched. And the strange twist? Rents actually dipped a hair last year, down about 0.5% on new leases. Didn't matter. That floor they dipped from was already so high that almost half of every renter in the country, call it 22.5 million households, is now handing over more than a third of everything they earn just to keep a roof up and a door that locks. Now here's where I part ways with almost every other video you'll find on this. Most of them will tell you the real fight is rent control. Get your state to cap it, and that's the whole ballgame. And I understand the instinct, but I honestly think that framing leaves regular people worse off because it trains you to sit and wait on a law that in your state is very likely never coming. That map hardly ever moves. What does move, what you could put to use tonight in a state with no cap whatsoever, is the second half of that letter, the half about warning, because almost nobody bothers to explain this next part, even in Texas, even in Florida, even in a state where a landlord could legally double what you pay, he still doesn't get to do it the second it crosses his mind. That timing was never his to decide. There's a specific stretch of warning the law says you're owed before that new number is allowed anywhere near your bank account. And when a landlord skips it, when he botches that one piece, and plenty of them do, the whole increase can land dead on arrival. That's the piece that's actually worth money. And it's the piece people toss in the trash almost every single day, usually within a week, by doing the one thing that feels the most responsible in the moment. They just pay it. Bill goes up, you cover the bill. That's how a responsible person handles it. And in the same motion, without ever meaning to, a lot of people hand back the one card they were still holding, because the timing is the whole game. That new number on the letter isn't real the second your landlord decides it. It's only real after the warning window the law gives you runs out. Every state sets that window. And the date he printed on the page, starting in 2 weeks, that's just his opinion of when it begins. But the law might have a very different date in mind. In most states with no cap at all, the floor is 30 days. 30 days of written warning before a single extra dollar can leave your account. And that's on a month-to-month setup. Some states and a couple of counties down in Florida push that to 60. And in the 3 states that actually cap the amount, California, Oregon, Washington, the warning can run all the way out to 90 days for a big jump. 90! 3 full months where the old rent is still the only rent he's allowed to collect. So picture the letter again. Rent climbing from 1600 to 1950. Date on it says 2 weeks. If you're month to month in a state that wants 30 days, that date's already wrong. He can start the new number in 14, not because he's a villain, because the paper he sent doesn't clear the bar. I'll admit, the first time I really sat with this, I read it twice because it sounds too good. A landlord who's legally allowed to charge anything he likes in a state with zero cap still can't make it start early? That felt like a loophole that couldn't possibly be real. It's real. His freedom to set any number and the rule about warning you first, those are 2 separate things written in 2 separate places, and the second one doesn't care how generous the first one is. Now, watch what that split does to 2 people. Same building, same state, no cap, 30-day rule. Same letter, same jump, same 2-week date printed on the page. One tenant reads that date, feels the drop in the stomach, and just starts paying $19.50 on the first because the letter said so. Her neighbor, same letter in hand, knows the warning was too short, knows the new rent can't legally begin until a full 30 days of proper written notice have actually passed. So he keeps paying $1,600 until that clock runs all the way out. Same landlord, same rules. That gap over the extra weeks before the increase could legally land came to $350 one of them didn't have to pay yet. And where a landlord botches it so badly he has to start the whole clock over, that gap can stretch past $700. Real money. One difference between them. One of them knew the date on the page wasn't the date that mattered. And this is where I have to slow down because the internet gets this part badly wrong. Does a botched notice mean free rent? No. Somewhere out there is a version of this that says if your landlord fumbles the paperwork, the increase is dead forever. Or worse, that you get to stop paying rent entirely while you fight about it. Please don't believe that one. A bad notice doesn't erase the increase. It delays it. Or more precisely, it resets the clock. Your landlord fixes the paper, sends it again, waits the proper number of days, and then the higher rent is perfectly, fully legal. What the mistake buys you is time, not a cancellation. And the fastest way to turn a winning hand into an eviction is to stop paying the rent you actually owe while you argue about the rent you don't. You keep paying the old amount, every month, on time. That's the part that quietly protects you. There's a whole side question, too, of what even counts as notice. Does a text message do it, a note taped to the door, an email? And the honest answer is, it depends on your state, and sometimes on what your own lease says, which is one more reason that folder on the counter keeps mattering. But set that aside for a second, because the thing that makes all of this bite isn't the rule, it's the math sitting underneath it. Rent's already 37% higher than they were 5 years ago. Almost half of every renter in the country handing over a third or more of their pay just to keep the lights on and the door locked. When you're that close to the edge already, $350 a month isn't an annoyance. It's the line between making it and not. And a few extra weeks at the old number, weeks the law might genuinely owe you, can be the exact cushion that gets you to the next paycheck or to the next place. On your terms, not his. So the real question stops being, can he do this? You mostly know that answer now, and mostly it's yes. Instead, it turns into what you do with that letter in the first few days, before you set up the new auto pay, before you sign a renewal, before you take the date on the page as gospel, because there's a handful of moves people tend to make with a letter like this. Quiet ones, and almost none of them cost a dime. That first one, most people skip. It's the one that feels too small to bother with. And it's just this. Before you do anything else, before you touch the auto pay, before you fire back an angry reply, before you even decide whether you're staying, you find that lease and you read the two things that actually govern you. When the term ends and whether you're month to month now or still locked in. That's it. 10 minutes. People skip it because it feels too obvious to matter, and it's the single most useful thing you can do because those two facts decide every move after. Still inside a fixed term? Then that mu number can't touch you until the term's up, full stop. Rolled on to month, then it's the warning window that's running, and now you get to check whether the date he printed actually clears it. The friction here is real though. Half the time the lease is in an email from 2 years ago you'll have to dig for, or it's a photo on an old phone, or, and this happens more than you think, you never got a signed copy at all. If that's you, that's its own small red flag worth sitting with. The next thing people do is figure out their own state's number, and I'll be honest about how unglamorous this is. You're looking for two figures. Is there a cap where you live and how many days of warning you're owed? And the best place to get it isn't some forum where a stranger swears he knows. It's your state attorney general's website or a legal aid page for your state. Washington's attorney general, for one, puts the whole thing in plain language right there for renters. Most states have some version of it. You'll spend 20 minutes and a little patience because government websites are government websites, but you'll come away knowing the actual rule instead of the version your landlord's counting on you not to look up. Then, and this is the one people are scared of, they put it in writing. Not a phone call, writing. If the notice looks short, the move most folks make is a short, calm, dated message, the date they received the letter, the rule as they understand it, and the line saying they'll pay the new amount once proper notice has actually run. That's it. No threats, no lawyer cosplay. And here's the friction nobody warns you about. The landlord who just goes quiet, doesn't answer, doesn't argue, just lets it sit, betting you'll cave from the silence. You won't get the satisfaction of a reply. What you'll have instead is a paper trail with a date on it, which is the thing that actually matters if this ever goes further. And underneath all of it, the rule that keeps you safe while you sort it out. You keep paying the old amount every month on time. I know how backwards that feels when you think the increase is bogus, but the tenant who stops paying to make a point is the tenant who hands the landlord the one clean reason to evict that has nothing to do with rent control or notice windows or anything you were right about. Pay the old rent. Protect the position. Let the clock do the work. Here's where I'll say the thing I'd tell my own mother if that letter showed up on her counter. Don't spend your energy fighting the number. Spend it on the timing and the paper. Everybody wants to argue about whether $350 is fair, and I get it, it might not be. But fair isn't the fight the law actually hands you in most states. The number he mostly gets to pick. The timing, the notice, whether he did it right, that's where regular people actually have ground to stand on. Aim there. That's the winnable part. And there's a point where you stop reading and pick up the phone. If the letter's tangled up with something bigger, he's raising the rent right after you ask for a repair, or right after you complained about something, or you're getting pushed out in a way that smells like payback. That's not a read the internet situation anymore. That's retaliation, and it's its own body of law, and it's exactly the kind of thing where a 15-minute video can't stand in for someone who knows your state and can look at your actual paperwork. Most places have free legal aid for renters. Dialing 211 will point you to it. There's no shame in that call. The shame is in guessing when you didn't have to. Everything I've told you is the general shape of how this works, what the law says, what people in this spot tend to do. It's not me telling you what to do in your kitchen with your letter in your state. A real situation with real money on it deserves someone who can see the whole thing. I mean that as a friend, not a disclaimer. But most of these letters never get near a lawyer. Most of them get handled at a kitchen table by somebody who took 10 minutes to learn 2 dates. So think about that letter again, the one on the counter, rent going from $1,600 to $1,950, 2 weeks printed on the page like it's already decided. For a lot of people, that paper just becomes a new auto pay by Friday and a quiet knot in the stomach that never fully goes away. But it doesn't have to be the final word the day it lands. It's a claim. His opening move, and whether it's the real number on the real date, that still runs through a rulebook he doesn't get to write, in a state that already made its call long before he ever licked the envelope. You don't have to win some grand fight. You just have to know the date on the page isn't automatically the date that counts. I don't know why nobody teaches you that before you're standing at the counter, holding it, doing the math. But now, you're the one in the room who knows.